Yes, please.
May I please, my lord? My lord, I beg to mention item number 5.
Item 5.
Yes, my lord, this is bail method may be taken up on 6th of.
Yeah, for the learned counsel for the petitioner.
Yes, my lord.
Praise for adjourning the matter today and listing it on 6th of August.
Yes.
Prayer is allowed. List on 6/8/2026. TCR is available.
Yes, my lord.
TCR is available.
Yes.
TCR is available.
Yes, ma'am. PCR available.
Scan TCR is available.
Yes, ma'am. Last time, the FSL was called for perhaps, madam.
Okay.
FSL. Obliged, ma'am.
Matter number 1, you can give it in a notice. You can give it in a dashboard. I have set. People may not be aware. No, councils may not be aware. Something like stuff. That's true. So we can give in the board. Yes.
May I please, madam? My lord, I'm aggrieved with the summon dated 26/6/2026, my lord. Whereby, my lord, the president and the secretary, Gambura Association has issued me the summon, my lord, to appear on 6th of August 2026, my lord. My lord,
Page.
my lord, impugn, my lord, page 40, my lord.
Gambura Association.
The type of copy is at
Just one.
page 41, my lord. Here, my lord, in fact, on the top, my lord will find, my lord, it is written Office of the Inter-Village Territorial Customary Court of Bilad Circle. But then down below, my lord,
The impugn order is a page.
impugn order, my lord, 40.
Project.
Yeah. The type of copy is at 41, my lord.
Type copy is the
Type code 41. Yeah. On top, it is Inter-Village Territorial Customary Court of Bilad. But down below, my lord finds, my lord, it is the President's Bilad Circle Gambura Association, my lord.
Secretary of Gambura Association.
Under the-
Would you be prejudiced if you appear and take it?
Not really, but then, my lord,
I'm just
there-
asking.
No, my lord. But then, however, my lord, can the Gambura Association, my lord, there is.
Ultimately, that question has to be decided.
Yes,
Of course.
no, that has been already decided, my lord. Therefore, my lord, if my lord comes to page 42, my lord, by the honorable court, my lord.
This is another revision.
Yeah, same issue, my lord.
Same issue.
Yes. Page 42, it starts from page 42, my lord. And the operative part, my lord, will find at page, it starts from, my lord, 9, my lord. 46. Upon considering, it appears that the respondent of 4 has made a complaint before the president of all Yachuli Gambura and Gamburis Association. Upon receipt of the complaint, the president and the secretary of the GB's Gambura Association has passed the impugn order and also issued 2 notices.
Only customary court and civil court.
Yes,
But
yes,
the question is that
the association, my lord. The and civil court, as they are not customary courts, within the meaning of the customary court under the honestly the Civil Court Act 2023. Under this act, the said act, only the customary court, by whatever name called, and the civil court have the power to decide the civil suit complaint.
So at this stage, they have issued the notice to you,
Yes.
and you think they do not have jurisdiction.
Yes,
That is the issue at this stage.
So therefore, my lord, at this stage, my lord, may I humbly pray, my lord, the notice may be issued, my lord.
And this may be stayed.
In the meantime, my lord. This is my humble prayer.
Perhaps.
There are 10 makes it very clear, my lord. In view of the provisions, my lord. The
Coding
Gambura and Buri.
Yes.
Madam.
learned counsel for the petitioner. Full stop. The petitioner herein, namely Nalik Saro, has invoked the jurisdiction of this court under Article 227 of the Constitution of India to assail a summon dated 26/6/2026 issued by the President of GB Association Bilad Circle,
President and General Secretary.
President and Secretary, and of G Gauhati Association Bilad Circle, directing him to attend the Inter-Village Territorial Customary Court on 6/8/2026. Full stop. The said notice has been annexed as annexer. What is the annexer? It is not coming here.
Annexure, my lord, it will be, annexure 6, my lord.
Annexer 6, and it reads as follows. Can you reproduce this? Full stop. Next paragraph. It is stated that in that Obang Padu, he's the respondent.
Obang Padung respondent number 1, my lord. He's the
Respondent number
complainant.
1 was agreed by the Kebang decision dated 2/6/2026 with regard to a land dispute between the petitioner and him, and has preferred an appeal before the Inter-Village Territorial Customary Court of Bila. Accordingly, the notice was issued to the petitioner asking him to appear. The next paragraph. Mr. Vada, learned counsel has drawn attention of this court that though in the heading it is mentioned Office of Inter-Village Territorial Customary Court, but the notice has been signed by the President and Secretary respectively of Gauhati Association Bilad Circle.
My lord.
Full stop. In this connection, the learned counsel has drawn attention of this court to an order dated 4/11/2024 passed by a coordinate bench of this court in CRP 40 of 2023. Full stop. It is contended that in similar circumstances, the said coordinate bench had had held that under the AP Civil Courts Act 2023, only civil court and customary court are empowered to adjudicate, and not Gauhati and Gauhati associations. Accordingly, in that case, a notice issued and a notice and the order passed by the President and Secretary of GB Association was set aside. Next paragraph. The learned counsel submits that this case is also similarly placed, and he similarly placed, and therefore, while notice may be issued, the impugned summons may be stayed.
My lord.
Next paragraph. I've given my consideration to the matter. How many respondents?
3, my lord.
3 respondents have been impleaded. The petitioner shall take steps for notice upon respondents by speed post.
No, by the, registry, my lord.
Registry,
Due person.
by the usual process. The petitioner is also at liberty to resort to dusty service, in which case a compliance affidavit shall be filed. Full stop. Upon giving my consideration to the matter and also perusing the decision of the coordinate bench, decision of the coordinate bench of this court, it is directed that till the returnable date, the impugned notice dated 26/6/2026
My lord.
issued by the President and Secretary of GB Association Bilad Circle shall remain stayed.
It's right.
Next date after 3
4 weeks.
after 4 weeks.
Pardon, my lord.
Yes, sir, right, as a matter of procedure, as the order has been passed in the ex parte, the respondents upon their appearance shall be at liberty to seek vacation or modification of the interim order of stay.
My lord, I'm extremely sorry, my lord. My lord, in item number 11, 12, 13, and 14, my lord, the CD was called for.
Just a minute. 11, 12, 13, and 14.
Yes, the CD was called for, my lord.
Hmm.
I'm extremely sorry, my lord. I'm yet to receive that CD, my lord.
Okay, okay. No, no problem. We have to wait then.
Therefore, my lord,
Anti-corruption bill.
yes, yes, my lord. And today it's fixed for hearing, my lord. But since
Okay.
I have not received the CD, my lord, may I humbly pray, my lord, if
Next week.
my lord.
Next. 11, 12, 13, and 14. Now it will be common order. Mr. Eugene Pada, learned special public prosecutor, ACB, Arunachal Pradesh, submits that the case diary as called for has could not be received, has not been received today, and prays for another date. The learned counsels for the petitioners are present. When would you prefer it? Next
Lordship,
week?
I will, I'm appearing for complaint. Informant complaint,
In all the cases?
all the.
No. Learned counsel, your good name.
You, Bori.
Learned counsel appears also is present on behalf of the informant. So you work out a date then next week.
In item number 13 and 14, I am for the petitioners.
Yes.
I said I have no interim protection has been granted to me. So
Interim protection, because it's a ACB case, I have to look and see the file. Otherwise, the other two interim is there.
my lord, there.
Other is there. Let me look into it. Otherwise, you take a short date. Today is Thursday. How about how about Wednesday? Wednesday or Monday even.
Next week.
Huh.
Wednesday.
Wednesday. Before signing, I'll look into it. This interim order, just remember, make a note of it. Huh. It is submitted that in AB 81 and 82, the petitioner has been granted interim protection. Learned counsel for the petitioner in AB 86 and 87 place for similar protection. I'll look into it.
Item number 2.
After some time, we'll take up.
Item number 3.
My lord, the senior counsel is engaged in the matter of our principal bench via VC, Your Lordship.
Okay.
I'm seeking for passover for the time being, Your Lordship.
Which item? Item 3.
Item number 4.
Mr. Allen, report.
Any information from the council? No.
Item,
I'm for the petition. Sorry, Your Lordship.
No, no,
I have seen outside.
no problem.
Your Lordship, both husband and
Joint petition.
yes, and Lakshmi Narayan cases, there is clear cut. The guideline has been made.
498.
498A is only the non-compoundable.
That is possible.
325 is compoundable, and they are living in the same roof for last 5 years, happily, peacefully with their 3 minor daughters. And due to the pendency of the case, the petitioner number 1 is facing hardship for renewal of passport or some other documents.
MP, Lakshmi, that's okay. No
And
problem.
there are also similar kind of 2 of my cases. Your Lordship, this honorable court has quashed the proceeding of the case. I have placed that one also.
Where is they have entered into an agreement
Yes, Your Lordship, they have entered into the agreement.
at page?
That is, Your Lordship, page number 48. Annexure 4.
Scan copy has been received, right?
Yes, my lord.
Started.
My lord, perhaps, my lord, there was some query from this honorable court, so as to get the, my lord, confirmation whether they are still living together or not, my lord.
Also.
Because perhaps they have taken one of the, ground in the settlement that they are living together, my lord.
And what is the feedback?
To that extent, my lord, we have to go through the, this, my lord, the trial court record, and my lord, and the last occasion, actually, my sister was appearing, my lord, and moreover, my lord, one more, issue she has raised that regarding the, my lord, signatures, my lord, it's not tally with the settlement signature, it's not tally with the petitioner's signatures, my lord.
Is it? The wife can come also then.
Yes, my
You
lord,
can-
they can be called before this
They
honorable
can
court, my lord.
appear also.
Yes, let them appear, my lord, in that
Because it
case.
seems there's a photograph of she suffered fractures and all. that.
Lordship, I would like to clarify on
Mhm.
this, first, on the motion.
No, there's no, we can, eventually we can, quash
Yes,
it,
yes,
but only, going through the proper procedure.
yes, my lord.
Lordship, I will give me few minutes. I'll
Yeah,
clarify your
sure, why not?
Earlier, it was that one of such kind of cases
Hmm.
came up before this honorable court.
Hmm.
The learned PP said that there was no such agreement between the parties. The one of the parties had opposed later.
Hmm.
So learned PP had directed for to call TCR. TCR was called, and after that another issue was raised by the learned PP regarding the endorsement of the case. Here was the two order about this. Earlier, it was endorsed before the court of learned CGM.
Hmm.
Then learned CGM has again endorsed to court of learned JMFC. There was some confusion regarding that.
Hmm.
Now it has not yet been trial has comment your lord.
The case is at the stage of investigation.
No, my lord, the charge sheet has been filed, my lord, because, my lord, because my sister has also marked the signature, my lord. My lord, for, my lord, ends of justice, my lord, what my humble submission would be, my lord, let them appear personally, my lord. Both, since it's a joint petition, my lord have the power. Let with the proper I-card, my lord. If they concede, my lord, then we don't have any objection. If
They
there has been-
appear before.
before this honorable court, my lord. That in earlier occasion also, my lord, in joint petition, my lord, because this, although it's a husband-wife dispute, my lord, but
We
we,
can appear, we can take in chamber also.
yes, my lord, let both of them appear before this court.
Mhm.
Then, my lord, may proceed to quash this matter. my lord.
Otherwise, there is no issue since,
Yes, yes.
this can be quashed.
Yeah, it can be quashed, my
Since
lord.
you have pointed out about some
My lord, signature.
purported discrepancy in the
Yes, yes.
signature, and secondly, she has alleged about sustaining, serious fracture injuries, and there's also one photograph of hers. So anyway, that will not be a bad idea. See, eventually we probably will be able to,
Of course, your lordship,
we'll be able to quash probably.
Yes, my lord.
But the thing is that the process should be
Yes,
satisfying.
yes, my
So,
lord.
where do they stay? How far from?
They are staying Doimuk, or this afternoon, your lordship, because main problem is because your lordship, the husband, who is the sole breadwinner, he is a businessman. He's facing lots of hardship due to the pendency of this case, your lordship, for renewal of passport, for renewal of his gun license, and some other documents. This is the ground to approach before this honorable court. If this case goes before the trial, before the learned trial court also, this will not serve any purpose. There is very remote and bleak chance.
We are not objecting on quashing, my lord. We just wanted to affirm whether,
In such kind of similar cases, I have filed before this honorable court 3-4 cases. That was outrightly quashed, your lordship. The original agreement is with me. Earlier, to my knowledge, it was that in one of the case, in such kind of case, there was some dispute regarding the settlement. For that, TCR was called was directed to court. TCR came. Again, after TCR came, there was another confusion. One magistrate had enrolled to another magistrate. There was question, which court the trial was going to comment. That was.
and my lord will find in page number 40, my lord, perhaps my brother is also one of the interested party, my lord, because he's the witness. He himself, my lord.
Oh.
So that is the reason, my lord, why the confirmation is required, because he is witnessing the settlement, my lord.
Anyway,
He's the counsel also, witness also.
better,
Better let them come before.
better to avoid actually.
Yes,
That,
yes.
since
Yes, my
the
lord.
council, better to
Yes, my
avoid.
lord, in
Anyway,
agreement and he is
for-
appearing, my lord.
For
Yes.
future, you
Yes.
can, probably avoid that. Let someone else be there, the witness. This case, you already, just take a, because suddenly if we call them today, only.
Not today, my lord, not today. Let, my lord,
Monday?
convenience that, yes.
Monday,
Yes, my lord,
as
no,
per your convenience.
yes, as per his convenience, my lord.
Well,
Your lordship,
do one thing, I'm telling you, you can just take a moment,
Yes.
outside and give a call.
Yes.
And ask them that, because of certain reasons, you come to the court, we'll make them comfortable, don't
Yes,
worry.
yes.
If necessary, we'll never call them here.
Chamber. only.
Chamber in privacy will
Yes.
do that, but when it will be convenient for them.
it would take only 1-2 minutes here, only to verify the party.
Ask them. They may have some difficulty also.
Yes, my lord.
Ask them once.
Yes.
Just ask them, give them a call.
I-
In the meantime, I'll dictate a part of the order.
Yes.
If they are ready, then tomorrow, your lordship. It will take 2-3 minutes, only to verify, your lordship, whether they are.
Tomorrow, no, tomorrow, not tomorrow. I mean, ask them when they can come tomorrow.
Let it be on
I
Monday,
have
my
some
lord.
Difficulty personally.
Yes, Monday
or
Monday or Wednesday, my lord.
Lordship, this afternoon, after lunch break.
There is no rush, my lord. Yes, sir. If
Yeah.
interim is already been granted by this honorable court, my lord.
Yes, your lordship, I'm quite pressing your lordship. In other cases, I have no any issue. Interim is there. It takes 2-3 years or so, no problem. But here, your lordship, problem is that the husband, he's facing problem is that
Yeah, please ask him, which date of next week.
Yes, ma'am.
Any day of next week, starting from
Next
Monday,
week, any day.
starting from Monday.
Yes, your lordship.
Learned counsel for the petitioner. Full stop.
If I might not be, the some other counsel will be there, your lordship.
No issue.
Okay.
No issue. no issue.
You take the telephonic instruction and let us know so that we can fix the date.
Document, your lordship, they come with Aadhaar card.
I-card, proper I-card.
Order dated
I-card
3/7/26.
recognize this,
Oh,
recognize.
You para second, you
Voter
take.
subtype.
Para sec. Para sec. Full stop. The FIR dated 14th March, 14/3/2020. 2020, right? Yes, was lost by the wife who has joined in this petition as petitioner number 2 against her husband, who is petitioner number 1. Full stop. The allegations are about causing of assault, resulting in fracture injuries. Full stop. The informant / wife has also alleged about repeated assault and mental harassment. Full stop. The case was registered as Itanagar Women PS case number 25 of 2020 under 498A 325 within bracket GR 177 of 20. After completion of investigation, the case resulted in a charge sheet being CS number 145 of 21 dated 21/10/2021 under section 498A 325 IPC. Next paragraph. It appears that subsequently the husband and wife entered into an agreement dated 10/6/2026 stating that they have amicably settled the matter and do not want to proceed with the same. Full stop. In this backdrop, the present quashing petition has been filed, where the informant and the accused, being wife and husband respectively, have joined together to seek quashing of the criminal proceedings, being GR 177 of 20 under so and so section. 125, same section, supposed to. The next paragraph, the learned counsel submits that the learned counsel, referring to the case of State of Madhya Pradesh versus Lakshmi, submits that What is the citation of this? Madhya Pradesh versus Lakshmi Narayan and others, 2019, 5 SCC 688. Submits that in similar circumstances, coordinate benches of this court have been pleased to quash the criminal proceedings in criminal petition 203 of 24 and criminal petition 50 of 2023. Next paragraph. The scanned TCR has been received. Mr. Atil Larned, additional PP submits that perhaps it would be prudent to direct the parties to appear before the court, as because there might be some discrepancy in the signature of the informant in the agreement vis-a-vis our signature on the FIR system. I have perused the materials and given my consideration to the matter. Full stop. The learned counsel is also agreeable to the proposal. Accordingly, the parties may appear in person on the next date fixed for the same, whereafter the criminal petition shall be disposed of. If necessary, the interaction with the parties shall be done in the chamber. Okay. So
Give that to you, let's say.
there,
Make them call.
please give to him, Santosh. That's fine, Mr. Atil.
Yes, my lord, that will suffice, man. Deeply obliged, my lord.
Item number 6.
Lordship, matter may pass over for it.
Timing.
Yes, consular, this matter is about to raise, Lordship. So pass over this matter. Much obliged.
Item number 7.
My place, Lordship. Lordship, this item 7, 8, 9 and
They're
are
similar.
connected, Lordship, arising out of same FIR.
My lord, case diary was called for, but in the meantime, my lord, it is culminated into charge sheet and charge sheet has been forwarded to the trial court, my lord. So now at this stage, my lord,
85 BNS means 498A.
yes, ma'am, yes, ma'am, yes, ma'am.
Cruelty, Lordship.
We can confirm it. Then.
Yes, my lord, it can be also done without even perusing the, my lord, this
Oh,
case diary.
Okay. But we'll get this thing. The interim is there in all the three.
Yes,
All the three.
Lordship.
Common order system. It is, you can take the para 2 and 3 from Kimal 22-6 order. No? You can take it. The petitioner was granted interim bail on 22-6-2026 with conditions. Full stop. And case diary was called for. Full stop. Next paragraph. In this context, Mr. Atil and additional PP submits that in the meantime, the investigation stands completed and has resulted in a charge sheet by CS number. Do you have the number?
My lord,
By CS number ...
this is the WT, my lord, inform the W,
Usually they mention.
has been charge sheeted by it has charge sheet number, my lord, 58 of 2026 under section 85, my lord. Charge sheet number 58 of saying. It may be made as a part of the record, my lord. Can copy of the-
The communication received from the IO may be kept in the record. It may be mentioned herein that section 85 BNS corresponds to earlier section 498.
98A.
Like this, I am not being able to remember, that,
Very
especially the
difficult for-
subsections.
Yes,
Subsection. BNSS now gradually we remember it, but BNS
Yes, Lordship.
take some time. Anyway, so in view of the penal provision involved, no need to write that. In view of completion of investigation, I am of the considered view that the interim bail can be confirmed. In such view of the matter, the interim bail is hereby made absolute, subject to the condition that the petitioner shall be available for trial if one commences, and shall not hamper or tamper with evidence, and shall not commit any cruelty or harassment upon the alleged victim only. The bail petition stands disposed of.
Deeply obliged.
7, 8, 9.
10,
10.
up to 10.
Up to 10.
Oh, four of them.
Four.
You can pass a common order. Well, there must be family members. there.
Yes.
Oh.
Actually, informant is. the
Husband
one.
is in, husband is in, which
Item
petition?
seven- Item 7. Lord.
7 is husband, the rest
Yeah.
are family members.
Rest-
That one line we can write, the petitioner in AB 68 of 2026 is the husband of the, is the husband, and the petitioners in the other three bail applications are his family members.
Family members.
Deeply obliged, my lord.
Item number 15.
May I, my lord? My lord,
Some orders, huh?
my lord, actually, I want to withdraw this matter since there is slight changes in matter. Earlier, it was not charge sheeted, but right now it has been charge sheeted,
Okay.
and one accused person is arrayed in the charge sheet,
Okay.
which was not mentioned in my mutual
You want to
agreement as
upgrade
well
your
as-
petition?
Yes.
Additional affidavit.
Since Your Honor, actually, I have not mentioned in my mutual agreement
Yes.
for that person,
Ah.
as well as in my petition. So I want to withdraw and liberty to file a
Well,
fresh application.
fresh. You are Mr. Tamin?
TG Tamin, yes.
Tamin, learned counsel for the petitioner, who submits that in the meantime, there is a subsequent development by way of submission of charge sheet in which one more person who is not a party to the agreement
Yes, Your
has been sent up for trial. Full stop. The prayer for quashing has been made on the basis of the agreement. Full stop. In this context, the learned counsel submits that he may be allowed to withdraw this petition and file with liberty to file a fresh incorporating the subsequent developments and the new persons. Full stop.
deeply obliged.
The prayer is allowed. The criminal petition is disposed of upon withdrawal with the aforesaid liberty.
Obliged, my.
Item number 16.
Yes, must.
Lord.
Nolan.
On last occasion, was the query regarding that order, infin order passed by the General Assembly of Delegates. So in fact, if we ferrule of this orders also, Lordship, in every para, it has been, only the name has been given as the General Assembly, but entire subject matter was in respect of the disputed land of the petitioner only, Lordship.
Just a minute. Let me just go through the last order once. Recommendation.
Your Lordship,
Like that matter today,
Yeah.
earlier matter, it was signed by Gauhati, whereby I recommended the petitioner's complaint.
In fact, it was originated from, on the basis of one issued by the Gaubura. Which subject matter will.
Okay. The impugn order is dated 22/5.
20 to 5, and then another is 19. 20 to 5 is the forwarding lawsuit. My complaint filed before the customary court.
Okay, okay.
Forwarded to the affiliate authority. Saying that he has already entered the witness in this disputed land, so he could not conduct the cover. Accordingly, it was forwarded.
We heard the matter, no, this one?
Yes, my lordship has heard. Only today is on that aspect, whether the another infin order that has been passed by the General Blaze Assembly can be partially quashed or not, lordship, which was the query given directed by this my lordship.
So you are aggrieved by the Parvana at the moment,
Parvana, and at the same time, lordship,
the
PPC.
ongoing proceedings.
yes, the already ex parte decision. has
Oh,
been passed.
decision has been taken.
Yes, lordship. But decision was.
Just let's recapitulate once.
Yes.
There was a proceeding before the village authority.
Yes,
So that again went against you.
yes, no, it was on my complaint also.
Okay,
My.
I see. Yeah.
My land has been endorsed by
Huh.
the respondent.
So your right was upheld by the village authority.
Lordship, I have filed a complaint before the place authority.
Mhm.
Instead of taking up my complaint, it was remanded, recommended to the. affiliate
Oh,
authority.
yes, now I remember. Mhm.
And during pendency and pursuant to that recommendation, Interblast Territorial Customer Affiliate Court issued a parwana, but for Kaba, but they did not appear before the Kaba. Thereafter, surprisingly, another Gaubura of same place issued a press parwana, directing me to appear before the Kaba, saying that some person had also lodged a complaint against you. And in said parwana, my complaint was also clubbed. Earlier complaint. Then
Though it remained pending before the
appellate court.
appeal,
Yes,
territorial,
yes.
inter-village.
But fresh parwana was issued by another Gaubura. And accordingly, Kaba was fixed on 19 lawsuit. Then on receipt of that parwana, I have submitted a writ petition saying that I could not appear on 19. But no lawsuit, they have proceeded with that proceeding and they passed the ex parte decision. In the decision lawsuit,
Remember now.
yeah. In fact, that decision, in fact, was against me and the subject matter which is adjudiced before the appellate court. Another
Today we have, the matters come for order.
Yeah.
The records are here,
records not called for lawsuit.
not called for.
Only today, lordship, on previous occasion, after hearing both the parties,
Huh.
my lordship was of the opinion that whether this impugn, instead of quashing this impugn ex parte decision, whether matter can be remanded back to the Blaze Authority for Kaba in terms of my first complaint.
Okay.
It was agreed by the parties, but only on the ground that lordship, if this ex parte order is not quashed, because the subject matter which is pending before the Kaba has already been decided by the Blaze General Assembly. That is why for that purpose only matter has been listed today. So lordship, my respectful prayer would be,
Yeah.
and since my senior is also considered to my prayer, so I humbly pray that this special resolution of General Assembly may also quash and direct the Blaze Authority to hear the complaint afresh by giving a opportunity to both the parties, lordship, because they are the competent authority, civil court, lordship, to decide the land dispute, civil matter, lordship.
And what happens to the matter pending before the inter-village?
Yes,
authority?
if my lordship is quash that recommendation, definitely, since they in fact they are not competent because they are the appellate authority only. The recommendation itself was wrong, lordship, against the law. The Arunachal Pradesh Civil Court says that the customary court, Blaze Authority, is the first instance civil court, lordship. He has to hear my complaint. So if my lordship quash that recommendation, definitely matter will be go to the Blaze Authority afresh.
Just for my lord's attention, my lord, that entire village, my lord, the proposed my lord, meeting has been returned back, my lord, to the original village authority.
Original village.
No longer it is pending there.
What would be your submission today?
My lord, my submission, my lord, if my friend submission is completed, my lord, I'll make my lord, small submission on the my lord, the second period of the petitioner, my lord.
You are agreeable to the remand.
Yes, my lord.
You are
Exactly.
agreeable to the remand, but
But
you have.
there's nothing to be discussed much here, is because the matter has to be remanded back, and my lord, ultimately the jurisdiction is the my lord, the village authority, my lord. So, my lord, regarding that village assembly decisions, my lord, what my lord would like to submit before your lordship is, if lordship interfere, my lord, this will my lord, affect the other the interest also, my lord. My lord, as on the last occasion, as I have agreed to the submission made by the my lord, the counsel for the petitioner is, my lord, the interference only in respect of the land of the petitioners and the sole respondent, my lord, not the other entire thing, my lord. As because this is not the my lord, simply the my lord, the decisions in respect of them only, my lord. It is for the entire villagers developmental.
You are also supposed to take some instructions, right?
Yes.
On this.
That was my instruction was lordship.
Regarding that was the issue.
Yes,
that
my lord. Yes, my lord,
he
exactly.
has no objection in principle to the remand,
Yes.
but he says that only the land
Correct, my lord.
of his should be
Yes, ma'am.
interfered. But you say that it is connected. Could you get any updated instruction?
Yes,
regarding the
Lord.
same? Yes.
Lordship,
What do they say?
that is why, lordship, may I take you to the inferior order, that 19 ex parte decision, page
Page
64. Lord.
64.
64. Why I am praying for the quashing of this special resolution? Because, lordship, this resolution was only passed in respect, of course, it was mentioning as a community land, but though the subject matter was that my two land and that deed of settlement declaration, Lordship.
Mm.
So I may take you to this points, Lordship.
Mm.
Page 64, why I'm praying for question, Lordship. 64.
Yeah.
Final decision of the jury, Blaze Assembly, Lordship.
Yes.
After careful consideration of informations, oral testimonies, admissions made by Sri Jummodirchi, father of the respondent herein, and his family members, the Blaze resolutions of 2023, the customary laws and practices of the Galo community, the executive order dated 18/12/2006 issued by the Deputy Commissioner, West Sem District, the resolution of the Basar Bango Gaubura meeting held on 22/1996, the principles of Bogumboka land and Blaze settlement area, the Blaze Assembly unanimously resolved and decides the following. Point number 1, declaration deed declared by null and void. Now, this declaration was made in respect of my Dodo disputed land. Now, by this impugn ex parte decision, they declared it as null and void, Lordship. Again, my right has been infringed by the authority who has not recognized under the law. The declaration dated 27/12/2025 executed and facilitated by Sri Jummodirchi and his family members in favor of Sri Doiriba, he is the petitioner before your Lordship, concerning the land known as Rokpokode is hereby declared invalid, null and void, under the customary laws, uses, resolutions, and practice of DC Blaze. The Blaze Assembly finds that the said declaration deed was executed without the knowledge, consent, approval, or authority of the Blaze community and is contrary to the Blaze Resolution 23, customary laws, and established facts relating to the status of the land. Accordingly, the said declaration deed shall have no validity, force, effect, or recognition within the customary jurisdiction of DC Blaze. Point number D, no individual authority to transfer community land. The Blaze Assembly holds that neither Sri Jummodirchi nor any members of the family possess any authority or competence to donate, transfer, assign, declare, alternate, or confer ownership right over Rokpokode. This is again my land, Lordship, which is subject matter of that Kaba. In favor of Doiriba or any other person, likewise, Sri Doiriba possesses no authority or lawful basis under customary law to claim exclusive ownership over Rokpokode. C, removal of unauthorized boundaries markers. The bamboo poles, iron rod, and other structures reportedly erected by Doiriba within the premises occupied by Sri Jummodirchi for the purposes of ascertaining ownership, or demarcating boundaries are found to be unjustified, contrary to Blaze harmony, and against the collective will of DC Blaze community. Accordingly, the said bamboo poles, rod, and structures shall be peacefully removed under the supervision of the Blaze authority. Upon such removal, Sri Jummodirchi shall immediately resume renovation and repair work of his residence and the Blazers of DC Blaze shall extend such assistance and cooperation as deemed appropriate. Rokpokode declaration, community land, and DC Blaze. This is my land.
Declared community land.
Yes. The Blaze Assembly unanimously declares and reaffirms that the land known as Rokpokode forms part of the community land of the DC Blaze. The land has been traditionally recognized, occupied, protected, maintained, and used by the Blaze community from time immemorial and shall continue to remain community land governed by the customary laws, practice, and resolutions of the Blaze Assembly. Protection of existing Blaze. All Lordship till the end of this point, the subject matter was against my land, Lordship, which is the subject matter of the complaint pending before the Blaze authority, customary court, who is the competent authority to decide the title suit, Lordship. Now, Lordship, if my Lordship is remanding back the matter to the Gaubura, and if tomorrow Gaubura decide the same points, saying that this is the community land, no individual has right to claim the community land, then only it will be suffice, Lordship. But the Blaze Assembly, how they can decide the title over the disputed land, which is the subject matter before the competent jurisdiction? Now they are interfering the jurisdiction of civil court.
Competent jurisdiction is?
Is the village authority, Lordship. That is why, Lordship, my humble prayer is, Lordship may quash this ex parte decision also. Remand it back to the competent jurisdiction village authority of DC village. Let them pass a appropriate decision as per the Arunachal Pradesh Civil Court Act. And whatever the decision comes, definitely if aggrieved party, they may go for the appeal, Lordship. But during pendency of this complaint before the civil court, how the village can decided, and that too, it was originated from the Farwana issued by the Gaubura, Lordship. Now, it was they are giving it the assembly color, but in fact, it was originated from the Farwana issued by the Gaubura as per Civil Court Act, Lordship. This is my, and during, if my Lordship not interfere this ex parte decision, then definitely how the customary court can also decide against this assembly decision, because it has already decided the title in favor of the community, Lordship. So instead of going into all this, my lords, my respectful prayer would be quash all this for
We
one.
do not have any records, right? Only this
Yes,
only
only
petition.
this,
It won't be necessary
not necessary.
if we remand.
For remanding the matter back to the
unnecessary.
matter the authority is concerned, matter
Yes.
the entire
Let them
record
take
may
care, yeah.
But to decide about part setting aside, what
But-
you said, that then records will not be necessary.
not necessary.
Okay.
Madam.
Anyway, I'll
But
just a minute. I will get back to you. Just
Well,
give me 2 minutes. I have a seat.
Well-
I'll just take 5 minutes. Give me that act, AFR as well as Santosh. AFR as well as Civil Codes Act. Okay, I just went through the synopsis once, right? So basically, once it was decided in your favor,
Lords,
once, then again they started encroaching.
yes,
Then you filed this complaint, the
Yes.
complaint dated 22/5/2026.
yes, Lords.
Mm, But, and the complaint dated to 22/5/2026 was referred to the inter-district,
Inter-district, who is the
Okay.
appellate authority.
Okay, so it remained pending there.
No, my lord, that has been again remanded back to the, my lord, the village,
It
original
has been
village.
remanded back.
Yes.
Remanded back.
No longer it is pending there, my lord.
Okay.
Between-
Thereafter, you received this 15/6 summons,
Written subject.
15/6 Parwana.
Okay. Yes,
You received the 15/6 from Sentoriba.
Center,
Gamapur.
another GB of that same DC place.
Okay, regarding this.
Yes,
And to this, you said that the matter was pending before the
yes, yes.
inter-district,
Inter-district.
but, and sought some time.
Yes.
But
and-
they went ahead with the decision on 19th.
Yes,
This
online.
is the thing, and you are agreed by that?
Yes, Lord.
You are seeking a fresh.
Yes, Lordship. As per civil code.
My lord, I'll come to that point, my lord. How this has been done, my lord.
Okay. Okay. So you complete your basic contention is that the remand should be done by setting aside the 19/6 order
19/6.
for decision afresh.
Fresh decision, competent court, who is the village authority who can decide, Lordship.
The decision in 19/6, as I am asking this question again,
Lordship,
it pertain to, according to you, only your land,
Lordship,
which was in dispute with
Lordship,
the respondent.
respond. And which is the subject matter of that complaint, which is pending before the customary court.
Anyway, should I come to him?
Lordship.
Okay.
May I please, your lordship?
Hmm.
My lord, decisions dated 19/6/2026. My lord, has been decided by the entire village authorities, my lord, that I have already pointed out, my lord. The DC village, my lord, may kindly appreciate one thing, my lord. DC village is a village, my lord, the consisting of so many areas, my lord, wherein, my lord, one of the petitioner is claiming, my lord, and that there are so many other villagers who, my lord, supposed to claim, my lord, their own land, my lord. Therefore, this decision has been taken in respect of the petitioners only, as because the petitioner only is the person who is claiming the community land, my lord, as of now, my lord. Other village, my lord, village area is a vast village area, my lord, wherein, my lord, so many other villagers are having, my lord, the small plot of land, my lord.
Decision of 19/6 declared it as a community land.
Community land, my lord. Not only in respect of petitioner, community, including, my lord, petitioner himself also, my lord.
Mm.
My lord, community land is only for the petitioner also, my lord, not only to the sole respondent and other people. my
But
lord.
his line of contention is that it was a dispute between him and the respondent.
My lord,
Right.
yes,
But while adjudicating the dispute, the 19/6 impugned order
Well-
declared the land to be community land.
yes, my lord.
Okay. So therefore your contention is that the third party interests are also involved.
Correct, my lord. Exactly, my lord. Third party, entire villagers, my lord. Third party, entire villagers' interests are affected, my lord, are involved, my lord. Now, my lord, decisions is not only a simplicity decision, it is a multifaceted decision, my lord. For, my lord, the issues regarding, my lord, developmental activities, other village, my lord, the developmental activities, the construction of road, and the construction of, my lord, the field, the construction of any other, my lord, the developmental activities for the entire village people, my lord, entire community, my lord. My lord, because of the individual, my lord, the underlying principle of taking this decision is, my lord, in village, my lord, what happened? The individual ownership systems, my lord, hampered the, my lord, the other developmental activities, because of which there is no, my lord, the common burial ground, my lord. There is no common playfield, my lord. There is no other, my lord, where Namgar can also be built, my lord, constructed, my lord. In Assam, my lord, there is a provisions for the Namgar, my lord, where the construction can be done, my lord. In our village, wherein, my lord, presently dispute arose, my lord, even there is no place for the construction of the Namgar. So therefore, the, my lord, taking this into considerations for developmental activities and for welfare of the entire villagers, entire community, my lord, this decision has been taken, my lord. It is not only in respect of the petitioner, my lord. So many others, my lord, more than 50, 60 families are involved, my lord. more than 50-60 families who are malad also the claims to be the donor of this village malad area malad. So therefore malad, may I take your lordships to once again to the impugn order dated malad the 19/6/2000 decision malad at page number malad malad page number malad page number 63 it starts from Annex 8 malad. Just for a moment malad, may I take lordships to page number
Three annex.
malad page
yes.
63 malad, lordship may directly come to page number 66 malad. Malad, who are the signatories malad? Village authorities malad. All together malad 100 malad 121 villagers signatories malad. Only signatories 121 malad.
Your contention is that the village assembly does not have jurisdiction. It's not a customary authority. Only the
Malad,
Gauhati.
I'll
Only
come.
the Gauhati.
Only the Gauhati and the civil court.
Malad, I'll come to that point, Malad. First serial number 1 is Malad GB, serial number 1. And second is also head GB Malad of the same village, where the head Gauhati Malad, the second Dirchi Malad, he is the head Gauhati of that village Malad. And the Malad, the third one, 6th, 4th, 5th, and the 6th, 7th, Malad, they are the Malad, the village Malad, the panchayat members Malad, who were the juries Malad. All together, Malad, 121 signatories Malad. Now, Malad, this decision has been taken considering the welfare for the entire Malad, the villagers. Malad may kindly appreciate one thing. This village is consist of Malad, so many other villagers where Malad, everyone is residing peacefully in their respective floor as community land, not by individual ownership Malad. Rest are not claiming Malad. Only the petitioner is time and again claiming this piece of land as to be his own private land, which is not Malad, totally not correct. It is false. Therefore, Malad, the decision has been taken by the village authority in respect of him only, Malad, not in respect of the other villagers. Malad, if lordship if interferes this Malad, the decision, Malad, there will be Malad, likelihood of the affecting the other villagers, Malad. Malad, rest of the villagers are not claiming. Petitioner is the only person who is claiming on this Malad, piece of land.
No, what is the issue to be decided by suppose it is remanded back?
Malad.
What is the issue that has to be decided by the village authority?
Exactly, Malad.
That whether this land belongs to the petitioner or whether it belongs to some other individual,
Correct,
or whether it belongs to the community.
correct, Malad.
Right.
That has to be decided, Malad. Exactly, Malad. That has to be decided. Malad, the best authority is the village.
That's correct, right?
Yes.
Okay. In other words, who has the ownership of that land?
Yes, Malad.
The person,
Exactly, Malad.
the petitioner, the
Petitioner.
respondent, or the community?
Or exactly, Malad. That has to be decided by the village authority without Malad interference by this decision, Malad.
The petitioner, not as a shareholder of the community, but petitioner in his exclusive right,
Exactly, Malad.
as a private property.
Right. There, as Malad, he is claiming Malad, but then Malad, the contention of the entire villagers is he has no Malad individual right. It is a community land.
No, but that has to be decided
Exactly, Malad. Exactly, Malad.
if it is set aside.
Yes, yes, Malad. In respect of this only, Malad, not in respect of other community. Now, Malad, Malad may kindly appreciate one thing. Malad, initially, Malad, this decision was taken, Malad, particular to this Malad piece of land. Malad, in the year 2011, one decision was taken, Malad.
The land is described in?
Land is described as Malad, the Rockford Code, Malad. Lordship will find at phase number Malad.
Rockford and Dodo.
Malad, Dodo is, I think, Malad, not mentioned, only Rockford, Malad. So therefore, Malad, that is
Rockford Code.
Rockford Code only, Malad, where the dispute lies is lying, Malad.
Disputed land is Rockford Code.
Located at Rockford, Malad, the area. Not entire land, Malad.
Hmm.
And even Dodo land is also not mentioned, Malad.
Hmm.
In fact, petitioner is also not claiming the land over the Dodo land, Malad. Now, in this petition, Malad, he has mentioned Malad, but in this decision, nowhere it is mentioned Malad, Dodo land, Malad. It is only in respect of Rockford land, Malad.
If we are going for an elaborate hearing, then there's no point in disposing of orders. No?
So, Malad, just for Malad,
These are,
Malad, since
only for limited purpose.
Purpose,
That without going deep
Yes,
to
my lord.
decide. Otherwise,
Yes,
we'll have to go, if we have to
Now,
have
my
a
lord,
full hearing,
why?
then we might as well call for the records and fix
Yes.
it for hearing.
No, my lord, matter may be
Hmm.
remanded back is because not for, my lord, my lord,
Because
objecting.
the remand, the remand has run into some complications, right?
Yeah.
That it cannot
No,
be remanded
No, my
with only to
there will be
decide.
no
this.
complication, my lord, is because we both are agreed to remanding, for remanding of the matter, my lord, to the village authority.
that's fine.
Only, my lord, that part, my lord, interference on the decisions of the 19/6/2026, my lord, where, my lord, the only in respect of, my lord, my time and again, my submission is in respect of the petitioner only, the interference is, my lord, to that extent, it is reasonable, my lord. As because, my lord, there is a admittedly, my lord,
Whether the petitioner with regard to the disputed land, the petitioner, that is the Rockport Koda,
Correct.
whether the petitioner has he has an exclusive right as his private property, something like that. Something
no,
like
no, my lord.
that kind of remand directions.
Exclusive right is not, my lord, with
No,
the-
that he claims it as, you claim it as your private property.
Exactly, my lord. He is claiming property.
So only
other
that much will be decided.
Yes, my lord. Yes, my lord.
Uh.
Yes, my lord. That much only, my lord. So therefore, without setting aside, without interfering the, my lord, decisions of the 19th June, my lord, if matter is remanding back, my lord, to decide that particular issue by the village authority on its own merit, my lord, that will suffice the entire person, my lord.
No, but will
yes.
that be feasible? Because the 1906 order says that this land is not the private property of the petitioner, it is community land. Now, if we ask them to decide again as to whether the land is his private land or community land, in a way, can it be done without setting aside the 1906
My
order?
lord, in respect of this particular claim, my lord, as I pointed out, my lord, in such, my lord, positions, my lord, there was a one declaration wherein, my lord, wrongly made by some other people that has been, my lord, the cost has also been imposed, my lord. If lordship perused, my lord, another, my lord, the provisions wherein it has been clearly mentioned that if, my lord, the my lord, wrong, because of wrong declaration made by some group of people, my lord, the cost has also been imposed, my lord. Fine has also been imposed, my lord. Lordship will find at
I've
least some-
seen that.
Yes, my lord. So therefore, this will go, my lord, the entire the village will be affected, my lord. So therefore, my lord, the keeping the interest of the other villagers, my lord, if set aside the impugn order only in respect of, my lord, the petitioner and the respondent, my lord, entire things will be sufficed, my lord. Firstly. Secondly, my lord, my lord, my lord, if the village authority is required to be decided on its own merit, my lord, decision of this 19 June 2006 will not having bearing effect in deciding the, my lord, the issue between the petitioner and the sole respondent in on merit, my lord. This will be not, my lord, taken as a reference, my lord. My lord, that, my lord, the particular may also be added as because, my lord, this will not having any inferences in the decisions to be taken by the village authority, my lord, in respect of both the petitioner and the respondent, my lord. Not the entire thing, my lord. It's because this covers, my lord, why I am, my lord, the submitting for the, my lord, the interest of this, my lord, the entire villagers. Only there is a, my lord, the one aspect, my lord. My lord, if this has to be decided, my lord, lordship has already seen the provisions, my lord, under CRPC, my lord, my lord, the CPC, my lord. The non-reader of necessity party is also there, my lord. The interest of the entire villager is also involved, my lord. If lordship may kindly appreciate one thing, my lord, there is, this is under the 227 of this Constitution of India. Read as the N, 115 of the CPC. What 227 says of the Constitution says, it is supervision. It is supervision. And the CPC says, if there is a provision for appeal before the other authorities, just for a moment, may I take your lordships to the CPC, CPC, why, I am, the objecting to the setting aside of this decision, just for that purpose only, not for the other purpose, Page, CPC 115, section 105, 115, sorry, I'm sorry, revision, 115 CPC, The High Court may call for the record of any which has been decided by any court subordinate to which the High Court, to such High Court, and in which no appeal lies, no appeal lies thereto, and if subordinate courts appears to have, Malat, I'll skip the rest of the provision. Malat, directly I'll come to Malat the subsection 2. Malat. The High Court shall not, under this section, vary or reverse any decree or order against which an appeal lies either to the High Court or to any court subordinate thereto, Malat. Malat, why I'm Malat bringing this on records to your before your lordship? Malat, there is if decision is taken by the village authority, whatsoever the call, whatever the name may be called for, Malat. Malat, appeal lies to the other appropriate forum, not before this honorable court, Malat. So therefore, Malat, may I take your lordships to again, Malat, the AP Civil Court Act, Malat?
No, it will not be possible this way. It will not be possible. It has to be heard. Because there is no consensus on the
Yes.
terms of remand.
Yes,
There is no
Lord.
consensus on the terms of remand.
Yes,
It
Lord.
will lead to complications.
Yes.
We might as well hear the matter,
Yes.
call for the records and hear the matter.
Yes.
That will be best.
Malat, in that case, Malat, may I'll file Malat the response.
Yes.
Just for a moment, Malat.
Sure,
just,
you can file the response. That
Malat,
will
just
help.
for a moment, Malat.
You can give a short written argument also.
Malat, just for a moment.
Even if we do that, we'll keep it short. The process will keep it short. Within,
Just for
say,
a moment,
3 weeks or
Malat. If
something.
lordship, Malat,
Within a month, we'll try to dispose.
Malat, if matter is remanded back, Malat, there will be no Malat even. Just for a moment, Malat. Malat, why my friend is Malat insisting for the setting of set of the Malat the 19th decision, Malat? It is not truly exactly correct, Malat. Even if Malat the hearing proceed ahead, Malat even after the determination, Malat the end result will be the same, Malat. To my limited submission, Malat. Now, Malat, Malat.
That is the fact, Lordship. The end will be same, meaning thereby, without quashing this 19 order, if my Lordship may also remand back, because this is the disputed fact whether the land belong to me or community. Who is the competent authority to decide, Lordship? The place authority, Lordship.
Just for a moment, Malat, may I take your lordships to the Malat the close, Malat. Section 2, Malat first Arunachal Pradesh Civil Courts Act 2021, Malat. Malat decision, the customary court,
Yes, village authority.
village authority, Malat.
A junior division or a customary court.
Malat, just for a moment, section 2, subsection D, Malat. What it says, Malat, customary court means means court of the traditional council, authority of a village's indigenous to the state by whatever name called, Malat. Whatever name called, Malat. And the call includes the court of village authority under section 5 of the Assam Frontier Administration of Justice
Village
Regulation.
authority.
Malat, this is the Malat, whatever the name may be called for, Malat, the village authority is the village authority as per the provisions under section Malat, the regulation 5 of the Malat, the Assam Frontier Administration of Justice, Malat. Malat, here, name are different. Malat, village assembly, name are different, but it is a village authority's decision, Malat. In other way, Malat.
Even if it is called assembly.
Yes, Malat. Whatever name called, Malat. In some areas, Malat, it is called Nyel. In some areas, it is called Mel. In some areas, Kebang. In some areas, Malat, some part of the state of different parts of the state, Malat, they are having their own different name, Malat. Bango level Keba, Malat, other territory, interterritorial customary
This
court.
explanation is also there. To,
Yes.
5.3.
Yes, Malat.
For the purpose of section 5,
Yes,
village
ma'am.
authority shall include members of the traditional village council, inter-village territorial council, or apex council by whatever name called.
Correct, Malat.
So and so, so. on.
Correct, Malat. That is the Malat. Yes. Now, Malat, if this is to be decisions of the village authority, Malat, alternative remedy is appeal, Malat. May I take your lordships to the next page, Malat, the amended portion, Malat. 2 pages, Malat, last portion. Lordship has already seen the Malat, the terms of the village authority. Whatever it is called, Malat, it is the village authority, Malat. Name is otherwise different, Malat, but we call it in different places, different district, Malat. Second, Malat, amendment, Arunachal Pradesh Civil Courts Amendment Act 2022, Malat. Just, Malat, directly I'll take your lordships to next page, Malat. Subclause 3. After the 4th proviso to the subsection 3 of section 15, following subsection shall be inserted, Malat. Next page, Malat. Last page, Malat.
Last page of,
Yes, madam. Last page of this amendment, madam.
last page of the amendment.
My lord, amended, my lord, the loose sheet which I've my lord, handed over to your lordship. Loose sheet, my lord. Just for reference, madam.
Arunachal Pradesh Civil Courts Act.
Correct, madam. Last page,
Okay, amendment of
Amendment, ma'am.
2022 amendment,
yes, madam.
right?
Third proviso, madam. The after fourth proviso, two subsection, lordship has got.
After the fourth provision.
Yes, madam.
Oh.
Fourth clause, madam, the fourth clause
Yes,
and
this we have seen, the
Yes.
inter-village customary code
in
or apex customary.
apex customary
Mm.
code. Madam,
From the
if-
village authority, it lies there.
Yes, madam. Madam, if my friend is agree by the decisions of the village authority or assembly authority or whatsoever the name may be called for, madam, the alternative remedy is to prepare an appeal before the the inter-village authority or the apex village authorities or the civil court.
Hmm.
That provision is there, madam.
And from the inter-village, it will lie to the civil judge union.
Correct, madam.
The court
Correct,
of civil judge.
The
union,
provision, statutory
Administrative
provision has
judge.
been granted, madam.
Depending on the pecuniary
Correct,
jurisdiction.
madam. So therefore, madam, the barrier for the insisting for this, the setting aside of the impugn order, if we go by merit of the case, madam, this is the exact position, madam. So therefore, my lord, without setting aside in respect of me and the petitioner, if it is interfered to be decided by the village authority, my lord, I have absolutely no objection. My lord, matter may be remanded back. My lord, the village authority is the only power to exercise and decide the issue between the petitioner and this all respondent, my lord. That's it, my lord.
But without without interfering with the order of 19, how can you remake a remand? Can you make a remand?
My lord,
Without-
in respect of petitioner only, my lord. We can, my lord.
Set aside with respect of the petitioner.
Correct, my lord. Yes, my lord. I am.
That is the common ground.
Yes.
That is the common.
Otherwise, non-joiner party will arise. Otherwise, civil revision petition, my lord, will be defect. My lord, again, other will be, my lord, the lordship has already seen the subsection 2 of the 115 CPC, my lord. It is all clear, my lord.
You're not agreeable to that.
No, no.
No. So it will
Absolutely
not,
not.
will not please take down the petition.
Let them find.
That will help. You can,
Hearing will be required.
Mr. K. Lolan and Kato, counsel for the respondent. There's only one respondent, right?
Yes, Lord.
Only one respondent, full stop. You can take para 2 of the order dated 2/7/26. It will be same. Nicely written, full stop. An attempt was made to dispose of the matter at this stage itself on the possibility of a remand back to the village authority to decide afresh the issue of rights to the land in question being Rokpo Koda. Full stop. However, there is disagreement with regard to the terms of any such remand. Full stop. Thus, while the learned counsel for the petitioner seeks setting aside of the impugn order dated 19/6/2026 passed by the General Assembly of BC Village and fresh decision by the village authority regarding the right of the petitioner to the land, semicolon. The learned counsel for the respondent submits that such a remand should be made only with regard to the rights of the petitioner and the respondent without disturbing the order dated 19/6/2026. Full stop. Next paragraph. In view of lack of a lack of a consensus on the terms of remand, it will be prudent to hear the matter. Full stop. Therefore, the revision is admitted for hearing. It's to call for the case record has to be called from where?
From that, village
Authority.
assembly, Lord.
General Assembly. Call for the scan record will do.
Yes.
Scan case record. Give me the particulars of the number which from the General Assembly of BC Village,
Yeah.
Lepa Rada, Arunachal Pradesh. with regard to decision dated 19/6/2026.
From one Siri, Malad, the specific name has also to be mentioned.
That will be mentioned. With regard to a complaint against Jumo Dicha and his family members. Because otherwise there will be,
There is, Lordship, number one, Center by GB, who are issued, Parwana in respect of this decision.
page number,
Page number 66.
And all records are also, Malad, supposed to be with him, Malad.
Yes.
page 66, which para you are reading?
Volume table given here, Lordship.
Serial number 1.
Is the name of the person who.
Yeah, General Assembly headed by Mr. Sentoriba,
Sentoriba.
GB, Kambura, DC. Full stop. In the meantime, the respondent is at liberty to file his counter on the issue. Full stop. Both the sides are, the learned counsels for both the sides are also at liberty to file a concise written argument
Lordship.
in points,
Lordship.
if so desired.
Well.
If you think that,
Well.
so we can do the process quickly also. Full stop. List the matter.
Malad, since we are appearing on behalf of the.
Yeah, the interim order shall continue. Yes, list the matter after 3 weeks.
No, Malad, after 1 week, Malad.
After 1 week, after 2 weeks.
After-
It will be. After 2 weeks, it will be in which column? Orders column.
Yes,
The
Malad.
records will come.
Yes.
Records.
Mm, mm.
Whether
Mm.
specific or-
After 2 weeks in the orders column. That will be
Right.
better. No, it won't take much time, but it's better. Instead of passing an order which creates more complications, it's better to.
The mail,
Yes, yes,
It will be difficult.
Yeah.
Develop.
Item number 2, pass over matter.
Yes, ma'am, yes. 2, 3, and 6 are passed over. Yes,
Is an application under.
Mr. Fukon, no?
Yes,
Mm.
for anticipative bail of the accused person. Accused is a minor Lordships, and therefore his father is appearing before this court. And a notice was served upon the accused person
He's a
without
minor.
name, without his name, Lordship, in page number 14. And FIR was registered in Shimpu PS under section 305B of BNS Lordship.
Mm.
FIR in page number 13. Page number 13, Lordship. Medic.
Yeah.
I mean Manoj Datta would like to report that my scooty bearing registration number so and so has been found missing. The vehicle went missing on 10/7/2020 at approximately 12:25 a.m. from Zoo Road near KS apartment, Itanagar. Despite making every effort to locate it, I have been unable to find the vehicle. The alleged accused person is minor of 17 years,
Mm.
and he is presently working as a daily basis labor at event management at Kerala Lordship. After received this notice by the family members, he returned to home, and now he is ready to appear before the IO, but apprehension of arrest. So he is filing this application before this honorable court, which fair to grant pre-interim bail to interim protection to be given to the accused person. Today is the 6 for appearance of the accused person, Lordship. Here in
Before
page
the
number 14. Today,
JJB,
yes, Lordship.
before
Before Shimpu PS,
Chimpu PS, but he claims to be a minor.
minor, Lordship. 17 years. So I have annexed his registration certificate issued by Board of Secondary Education, Government or some.
Where is it?
In page number 8, Annexure 1.
Page number 8.
Yes, Lordship. Date of birth is 1/3/2019, 2009. Okay. And 17 years, 3 months. Page number 8.
Just 1/3/2009.
Yes, Lordship.
And alleged date of offenses.
And 10/7/2026. As per FIR, Lordship.
17, but yeah. He'll be 18 years only in March 2027. Okay. But there's a division bench judgment of a High Court
Yes.
which had clarified this position, that even if the word apprehension is used,
My lord, yes, my lord.
the anticipatory bail will be maintainable.
Earlier it was not found to be not made. This is there.
Yes,
In my lord, Dasrath Roy versus alias Deep Jyoti Roy.
that's the decision,
My
the
lord,
division bench one.
yes, my lord. The Dasrath Roy, Deep Jyoti Roy, anticipatory bail number 3286 of 2023, division bench of our High Court.
Okay, it was clarified. It was referred actually.
Yes, madam. It was, judgment was on 29/7/2024.
So anyway, this, he cannot be arrested, so.
Yes.
mm,
We, CD may be called for, because my lord, now they are claiming this, he is minor.
But he
They
has
may
to
have the
be,
document that,
But he has to be given a
yeah,
interim.
yes.
or
No, it
prima
should be,
facie,
because,
the board document is annexed. Prima facie, he appears to be.
yes, my lord. The otherwise also, my lord, the annexer 3, my lord, page 14, my lord. This is the notice under section 35(3).
Mm.
My lord, this, now, my lord, this section 35(3) is now become, my lord, to my humble understanding, is become, my lord, no longer, my lord, it's become redundant. Because, why? Because it is, normally it has to be issued in the cases where arrest is not required. Despite, my lord, this, the guideline, the direction has been given by the Supreme Court in Ernest Kumar case, and further it was clarified in Satyendra Kumar until matter again, when it says, if under 35(3) a notice has been issued considering the fact, and this fact, if the fact remain same, and accused appear before the IO, then police cannot arrest, shall not arrest the accused.
No, even then, if he has to be arrested, specific reasons have to be.
Then, my lord, again, the Supreme Court said the additional, the material which were not there at that point of time when the notice was issued, that has to be looked into, my lord.
Law will require further development.
Yes, it's required, it's debatable. Why? Because, my lord, one says 35, when 35(3) is required, when arrest is not required. Now, the police are issuing 35(3). Despite 35(3),
May not be required.
yes, then they are approaching this court for anticipatory bail. This is, my lord, some
That's,
very, my lord.
that has, I have also noticed this. Anyway,
Yes, ma'am.
Mr. Fukun, learned counsel for the petitioner. And Mr. Ate, learned additional PP. The petitioner invoking 482 BNSS is seeking anticipatory bail in connection with Chimpu PS case number 63 of 26 under so and so section. The case was registered based on an FIR dated 10/7/26 lodged by one Manoj Datta with the allegation that his two-wheeler bearing registration number AS22K2271 was found missing. And he sought help of the police in locating the same. Full stop. It is submitted that petitioner has received the notice, the
Guardian of the petition.
the alleged accused person, the guardian, notice was received by guardian.
Yes, Lord.
The petitioner,
No name is mentioned.
the petitioner, the notice was addressed at whom?
No name is mentioned. As minor, that's what most likely.
Notice has been received by the petitioner for appearance of his son in connection with this case. Full stop. Next paragraph. It is the contention of the petitioner side that the said son of the petitioner is a minor, aged 17 years,
3 months.
3 months, and therefore a minor. Full stop. In support of the said contention, a copy of a certificate issued, certificate of the School Education Board, Assam, has been annexed, in which the date of birth is mentioned as 1/3/2009. The date of offense is the earliest date of offense is 10/7/2026. Next paragraph. In what is the Dasara tree? Kindly give the number. It must be a reported case now. Dasara, yes. ... Full stop. A division bench of this court clarifying the position held that despite use of the word apprehension instead of arrest with regard to a CICL, and the anticipatory bail would still be maintainable. Call for the case diary from the concerned police station. However, in the event of apprehension of the petitioner's son / CICL in connection with this case, he shall be allowed to go on a personal bond of rupees 10,000 made by the petitioner, stated to be his father. He cannot give a bond. Father's petitioner stated to be his father. Leaves the matter on. Your convenience.
13.
13. Yes, please.
Obliged.
Item number 17.
3 and 4.
Somebody want to adjourn this matter.
Huh?
Lordship,
17 is the, okay.
if I may, the learned senior counsel is engaged in the other courtroom.
Okay.
So I've been instructed to seek for a adjournment
Okay.
for the matter
Timing or for the day?
for the day.
For the day.
Maybe listed after
Maintain-
1 week.
Maintenance matter, huh?
Yes.
Full stop. I mentioned it is submitted on behalf of the leading counsel that due to being preoccupied in another matter today in the court, the matter may be adjourned today and posted after a week. After you have further respond, the learned counsel for respondent is also present. Full stop. Respondent 2 or respondent? The maintenance matter. Maintenance matter, yes. For the private respondent is also present. Full stop. The prayer is allowed. Leave the matter. You want me to fix a date? 10? How about 10?
Okay.
10 is okay? Do it on the next day.
Obliged.
Yes.
Item number 3.
Yes.
One of my younger was to appear. I was occupied in principle.
No problem.
But this case stems out of a civil qua bit of the cheating.
Mm.
This the lady called Mrs. Sonu.
It's come up for the first time, huh?
Yes.
Okay.
She reported to the police station seeking a personal protection, my lord. That my lord will see at page 29. I'll assist the court, my lord.
Mhm.
This is handwriting version, my lord. Prayer for safe custody, my lord.
Owner of local, what
Local
has-
beats, my lord. These are
Beads.
in lakhs, my lord. Some of the beats. It is the
Which was
value is
K
in
for,
crores.
oh, I see, I get it.
Yes, is in crores, my lord.
It's very valuable, huh?
Yes,
Very
very
valuable.
valuable, my lord. So, my lord, this madam, she wrote to the officer in charge on 3/5/15, my lord,
Mm.
seeking a personal protection. So then thereafter, what had happened? Can you come to page 35? 31, my lord. While she was seeking and she was inside the police custody for a safe protection, then this group of people, my lord, the type copies starts from page 32, my lord.
It's okay.
Against that madam, this one madam called Yanam and
Oh, the beads were kept and some money was taken.
yes, that was that happens to be one new source of business now in Arunachal.
So
My lord, kindly see this
people are
the box.
short of jobs also, no?
My lord, kindly see 1 crore and all those 20 lakhs, 30 lakhs. These are the values, my lord. So that what had happened was, my lord, then this case was registered, my lord. Annexed to, my lord, page 34. On the basis of this complaint, my lord. Then this Then thereafter counter complaint was lodged, page 34, my lord, by Mrs. Sonu, page 34, my lord.
No, this is one complaint. This is 2015.
Yes. This 23/6/2013, my lord,
And page?
page 34, my lord. And the sections involved where my lord will see case number 56 and 2015, case number 467, 47. On the top, my lord will find 471, stroke 420, and 500 IPC, and endorsed to SI so and so, my lord. So then what happened as a counterblast, because the officer in charge and the investigating officer, my lord, were in a inquiry stage. So then, my lord, what had happened was this complaint under section 200 was filed. My lord will kindly come to page 37.
No, initially what happened was there's 9/5/2015 complaint was filed,
Yes,
right? A case was registered,
case was
42/15.
correct.
And then
Then thereafter,
another
first this
Sonum Nabang.
the who is acquitted, discharged by
Okay.
the session court.
Okay, let's proceed. Then this was filed.
Then this was filed as a counterblast because the IO and the officer in charge, they were on a preliminary inquiry because it is a commercial transaction between the parties. So in order to ascertain, then this as a measure of counterblast, my lord, they have filed this complaint under 200. Then simultaneously, my lord, kindly come to last page, my lord, page 85. On the same course of action, my lord. On the same course of action, my lord, this complaint was filed, my lord. Page 85. my lord.
This was against Tana Yanam
Yes,
and complaint against
Huh.
Chuku Nanobui.
yes. That the one who has filed the complaint petition under section 200, my lord. So then again she files here, my lord. Again, my lord, before the police officers. Then, my lord, the very pertinent point is here, my lord. The kindly come to page 51, my lord, for a moment. There was an special investigation. SIT made a detailed inquiry, my lord.
51.
51, my lord. I apologize, my lord. This
No, sir.
documents were not.
No. Inquiry was?
Yes. Inquiry was conducted, my lord. SIT PHQ per person to this, my lord. The complaint dated 11/8/2015, my lord. 2015, and then, my lord, see all the complaints, everything's were answered, and then, my lord, will kindly come to last page, page 104, my lord. Sorry, my lord, page 53, my lord. The finding of the SIT. After dealing with everything, the SIT has given the clean sheet to both the officers, my lord. My lord, see,
Okay, so no substantive evidence
yes,
was found.
yes. My lord, may I request, my lord, kindly indulge together to paragraph 10 onwards, page 53.
Okay. Raising demand of money.
Regarding demand of money by inspector so and so during inquiry, nothing as such was found, my lord. Para 11, regarding alleged illegal detention of Sonu Nawamtok, matter has already been explained in para 4 above, my lord. She sought a personal protection, my lord, that my lord has seen this. Now, finally, my lord, para 12, regarding change of IO for 2 days, the endorsement of case to a particular officer and change of IO while the case is under investigations are administrative reasons of the authority of the department. In course of inquiry, a complaint was received from Anti-Corruption Crime Committee, Arunachal Pradesh, copy enclosed. And while going through the complaint, it was found that the allegation against the official were same as alleged by Tana Yanam. So this is another ground. Now the OCPS has strictly been alleged for non-furnishing of seizure memo of 8 lakhs of local dal, which were allegedly seized by so-and-so exploited para 1. Illegal detention of Sonu Navam of para 4, registration of WPS case number after 43 days of receipt, para 7. My lord, then demand of money and harassment in the name of investing explained in para 10. Inference. Under the facts and circumstances in Amanatevok, no any substantial evidence found against Inspector C. N. Bui and Sub-Inspector 13 of WPS as alleged. Hence, the allegation level against the said police personnel was not established during the inquiry and found not proved. Now, thereafter, what had happened pursuant to this, my lord, the exoneration was there. Then, as a counterblast, they filed this complaint before under Section 200 before the Chief Judicial Magistrate. Now, they kindly come to page 59, my lord. The order passed by the learned Chief Judicial Magistrate. Now, this we need to read together.
6.5. You are seeking quashing of what? There's no synopsis here. You're not there.
Okay.
Anyway, let us.
Eat my hands, my lord.
Anyway,
Just only half an hour preparation I came.
no. Let me also.
Just
Just
why, my lord, I have
the
taken.
quashing and setting aside the MP and order.
Yes.
Is it in my part?
Paragraph 1 normally of this read petition is the fact, my lord. The prayer.
Judicial magistrate whereby cognizance was taken on the one of the IPC in charges who framed against applicants who are public servants.
Because
Two
Mr.
applicants.
Ete is a good public prosecutor, my lord.
Just
He might come out with lot of.
is quashing of the entire criminal proceedings.
there is-
No, you are seeking quashing of the entire criminal proceedings
Yes,
of CR number
Yes, yes.
an impugn order passed
Yes.
by the learned and so by
Correct.
secondary evidence. Fresh secondary cognizance taken.
After, I will rely one impugn order only. Then, my lord, I'll rely. Because I'm seeking, my lord, in any case there is TCR is required. No, just.
Okay, I've gone through it now.
Yeah.
But the impugn order now is at
My lord, kindly read
6.5.
80. No. 19 my lord. Page
19 to yes, yes.
page 52. my lord.
We have to see that first.
Then I have a small, my lord, legal submissions. This is
82.
seeking in prayer for them.
82. He has taken bail in this case. He's there on bail.
The case is at the stage of examination of prosecution witness. my lord.
It's on trial is going on.
Trial is going on. my lord. 19/2/2020. my lord. Case is fixed today for so and so, Sonu Navam, my lord, the first one, and so are present with so and so. The complaint in the present case, my lord, I'm reading from Tera.
These two accused are the petitioners here.
Yes. The complaint in the present case has filed this complaint to take provisions of the offense under section 120B, 327, 409, 420, 506 IPC against all the accused persons. The case of the complainant is that the accused number 1, who was officer in charge of the women police station, And accused number 2, the investigating officer of Itanagar WPS case number 42/15 had asked her to appear before the police station without any FIR being registered against her. It is further the case of the complainant that she and the accused number 3 used to give loan to private individuals by keeping the traditional deeds as security. Before filing of the FIR against her, accused number 1 forcefully made her to pay a sum of rupees 4 lakh to one so and 2 occasions. It is further alleged that complainant was asked by accused number 1 and accused number 2 to bring the 8 strings of traditional deeds to the police station. The complainant brought the deeds to the woman police station, which was kept by the accused so and so. Thereafter, the complainant asked SI Omang Patel to provide her seizure memo, but the same was not furnished to her even after several requests. The complainant, my lord will mark this, the complainant thereafter written a complaint to the SP Capital Complex against the alleged accused so and so for carrying out. The petitioner number 1 is not involved here. Of the investigation in the unfair manner and causing harassment in the name of investigation. The complainant had adduced 8 prosecution witnesses. Upon picking all evidence, I am of the opinion that there is a ground for framing charge against the accused person, namely so and so, under section, my lord will mark, under section 166A of the IPC. As the witness did not stated anything against accused so and so, hence accused so and so is discharged from the case so and so. Number 2 things are there. Once the main accused who took shelter before the police station has been exonerated, discharged from here, not fully exonerated, discharged. And then section 166A of the IPC was charged against us. And different, my lord will mark, earlier sections was normal IPC, but this is 166A, my lord. So my small
66A of IPC.
disobedience of lawful law.
Can you give me the IPC? Yes.
8 witnesses, huh?
Yes, 8. Knowing disobedience of a specific direction of law, my lord. So in this case, there is no such directions. There was no such directions where the petitioner applicants, my lord, have willfully disobeyed the law, my lord. This
Publics have a disobeying direction on the law.
Yes. My lord, why I am saying is the petitioner at that relevant point of time, we are conducting a preliminary verification, my lord, concerning traditional beats that Dal, my lord, brought to the police station in connection with the civil finance, my lord, dispute between the private parties, my lord. So definitely at the stage of preliminary inquiry, it will always be there. Now, the question comes, my lord, the immediate question comes, what is preliminary inquiry? What is preliminary inquiry versus formal seizure, my lord? What is preliminary inquiry versus the formal seizure, my lord? Now,
Just before we spend more, I'd like to say, you would not be applying, would you be appearing in this case? Because it's a complaint case.
Sorry, my lord.
It's a complaint case.
Yes, it's a complaint case, my lord.
But still, because the records will be necessary, you know, we
Yes,
have to see the depositions,
Yes,
whether, because it cannot be a parallel trial. We have to see the depositions.
Yes, my
and
lord.
see
And
whether it should be quashed.
before that, my lord, if the records are there, my lord, my senior counsel
Records
also.
is not there.
But if they have annexed the record of the High Court also, earlier also they approached this court for quashing, my lord. That was not interfered by this court.
no, that was.
The same complaint number 73 of 2015, my lord.
Just a minute, I'll come back to you.
Yes, my lord.
The order has been annexed, I believe.
Yes, order has been annexed, my
There,
lord.
Lord will peruse, brother. Today, we are not arguing on the merit, my lord.
That's certainly,
So just,
because instead of staying the proceedings,
Yes.
staying the trial, since they are already on bail, we can always say that it should not be disposed of, you know, till pendency of this, till the returnable date.
Yes,
And
my lord.
secondly,
that-
One, my lord,
but
I will
that,
raise issue
I
on.
agree to that.
No.
We will that at the
Or another thing,
on the final stage, you can raise this. We argue on
No,
because
my
on
lord,
merit, we can argue together, my lord.
but merit we will argue definitely, my lord, but on maintainability also, my lord, one issue is there, my lord.
Keep the issue open, my lord.
No, no, my lord,
He raises.
so anyway, what is the RDO order?
My lord,
Which page?
my lord, sir, earlier High Court.
I saw that order.
It's on page number 62, my lord.
62.
Yes, madam. Annexer 6. Same complaint.
This is a different order, 6-5. Order passed by the so and so, so and so.
This is different order. We are challenging.
Quashing the
different order,
complaint.
my lord. Not the earlier order.
Respect to
This
police.
order passed in the
Case of the
earlier
petitioner is that
application by the
considered
Honorable High Court.
lost.
It's on a different.
Committed that another.
That was for the normal Indian Penal Code sections, but others, it is now.
No, what is the 6-5 order? Is it here?
Yes, man, it's there, madam. 6-5 order is there, madam.
Yeah.
That is the cognizance order, madam.
The cognizance order.
Yes, madam.
And this one is charge framing order.
Yes, madam.
So we are not into that cognizance. I'm not entering into the cognizance
Anymore.
anymore.
Only
Then,
the
my lord-
charge,
Then quashing of complaint is not possible.
charge framing order.
Yes. Only to that extent.
No, I mean, it will amount to that only because if only one section charge has been framed
Yes, madam.
and that is set aside, the matter goes, the
My,
proceeding
but,
also goes.
my lord, but the cognizance basing on which, yes, my lord, the framing of charge, my lord, so far as the charge is concerned, that may goes if no ingredient is attracted, my lord.
I think.
But my lord, one issue is, my lord will find the impugn order.
Hmm.
It's 19/2/2020. Long time back, 5 years back, my lord.
Hmm.
Now they're approaching now by invoking, my lord, the inherent power of this court, my lord.
Hmm.
It should be the revision, my lord. Reversal of the order will culminate the proceeding, my lord.
No, that's
What,
charge framing is also challenged in revision also.
Yes, my lord, in revision, basically, my lord, because reversal, it's an intermediate order, my lord.
Hmm.
If it is interfere, my lord, why I am submitting, my lord?
Issue a notice and call for a scan copy.
Yes, my lord.
Without anything else.
Yes, my lord. Because, my lord, we are concerned on the, my lord, stay of the proceeding because High Court has earlier not interfere, my lord.
what the additional PP is submitting is probably, I understand, is a bit contrary to the principle laid down in Fatima BB.
Because it is the considerable delay is also there, plus an earlier round is also there.
My lord, kindly see, 2015 incident, and then you take cognizance, frame charge in 2020, my lord, and then the punishment is only 6 months.
That's true. But the thing is,
Therefore, my lord, kindly see the proposition which the learned additional public prosecutor has raised. To my mind, something it will not work.
no, the cognizance cannot be reopened anymore.
Yes,
If
my
you have
lord.
not gone to the Supreme Court,
Yes, my lord. Absolutely, my lord.
right? Because it is
So therefore, my lord, we are challenging the
charge framing.
charge framing only to the extent of 166A only, my lord.
No,
Nothing else. Nothing.
charge has been framed under which sections?
166A, my lord.
My lord.
That is what?
That is only this much, my lord.
If
So
the-
therefore, what I am contending at this moment is, you do not, there is, once there is an clean sheet from the SIT, and on the same fact and circumstances and same course of action, there cannot be a prosecution on the same fact.
And let the
So
senior
then
counsel
the
complete.
the other point which I am saying is, if he is referring to why there is a delay of approaching this court, the Germany started by the 19 to 2020, my lord, is
Just a minute.
Is
Just a minute.
that impugned order. Because jurisdictional case, my lord, I understand can be raised at any stage, and is not sanitized by an earlier order that.
No, because
did
see,
not,
please,
consider-
please come to page 81 and first para, last line. Come to please 81. No case is made out to quash the impugn order, which is 6/5/2000.
Yes, absolutely.
Or the proceedings of CR case.
Yes, my lord.
So the cognizance order has
Cognizance, I am not challenging,
yes.
my lord.
And the quashing and the order proceedings.
Yes.
the proceedings cannot be quashed.
Yes,
What you can do is you have to file a revision to challenge the charge order.
yes, my lord. Absolutely, my lord.
Read with 480,
Yes,
the
ma'am.
charge order.
The
You
charge can
cannot
be
quash
altered.
the proceeding.
But my lord, cognizance, so far as the cognizance is concerned, my lord is aware that the cognizance is taken against the offenses. The court found that there is an offense. Indeed, the offense is there. But, my lord, considering that aspect, the cognizance order was not quashed. Now, my lord, quashing the complaint is amounting to, my lord, review the earlier order of this ordinate, the coordinate bench, which is not permissible, my lord.
It will be permissible to, I mean, delay aspect is different, but
Yes.
it will be permissible in law to, file a revision.
Yes, absolutely, my lord.
File a revision with delay canonical.
Yes, my lord. That is what I'm submitting. My lord. I'm not saying it's not maintainable, but it is by way of
Will
revision.
issue notice without
Yes,
anything else.
yes, without anything, my lord.
Yes, at this stage.
My lord, that's why I'm saying, my lord. Can you just give me 1 minute? I will satisfy lordship. Just 1 minute, my lord. I just.
That what kind of interim order are you seeking? Because you are also agreeable to issuance of notice, right? What kind of interim order you are seeking? Kindly make a summation on that.
My lord, yes,
What kind of interim order and in submissions in
Yes.
support of that?
yes, I'll place this. My lord, see the SIT finding, my lord, I have taken.
No, what kind of, be to the point. What kind of interim order you are seeking? What kind of interim order? Because we waste a lot of time in.
Returnable date, let the proceeding be suspended.
No, that will not be possible because there are infirmities. That will not be possible. We at best we can say that the trial should not be, the judgment in the trial should not be pronounced
Yes, that much.
till the returnable.
Till the returnable. That much, my lord. Yes, my lord.
That will be, that will not,
Fine.
that will not prejudice you because
Yes.
you are on bail and you are participating in the trial.
Yes, ma'am.
We can even observe that you can seek appear to representation provided the identity won't be disputed.
Yes, ma'am.
That can.
Or alternative, my lord.
Hmm. But he's right, actually. You have to, if you are aggrieved by the charge framing under 166A.
Yes,
Right? That is the only section under which charge been.
Yes,
been
my lord.
framed. So since quashing of the criminal proceedings has already been, looked into once.
Only been
Therefore-
tested by this body.
Therefore, I have to challenge
I
the charge order through revision read with 482. You can
482.
add to that.
I just, that's why in the opening sentence itself, I said I have laid half an hour only, my lord. So, my lord, I will rather pray for liberty be granted to file review petition,
Revision petition.
revision petition, so that the question of delay will not be there. Because the party
It's already been done.
no delay is there, my lord. Delay is there because there is a wrong advice.
Or you
by the
take
court.
instructions if you want, you can take instructions also.
No any order, my lord. Because if liberty for modification, my lord, then there cannot be any interim protection.
Should we?
No, I am not seeking.
No,
interim.
he's not seeking.
Yes.
This is what you understand is.
No,
different,
not
my
seeking
brother.
interim.
Don't make this kind of submissions. This is what I'm saying is, ultimately what I'm proposing to the court is that you
To withdraw and liberty to file a revision.
file a revision petition.
You can take instructions or you
No,
want.
that's I take this.
Okay. Heard counsel, learned counsel from. Stop. The petitioner herein is agreed by order dated 19/2/2020 passed by the learned CJM. Learned JMFC 3 UPA in CR case number 73 of 25, whereby charge has been after taking pre-charge evidence, right?
Recharge.
Charge has been framed against the two petitioners under section 166A of the IPC. Full stop. In an earlier round of litigation, the petitioner had challenged order dated 6/5/2016, taking cognizance in the said complaint case, and also quashing of proceedings, which however came to be dismissed by order judgment and order dated 30/5/2017. Full stop. The learned senior counsel, after addressing some arguments, submits that perhaps he may be given liberty to withdraw this petition and explore the possibility of challenging the said order of framing charge by way of revision. Full stop.
Submitting that, jurisdiction can be raised at any point of time. That's it. That's
If it is further submitted
jurisdictional
that
question can be.
it is further submitted that the question of jurisdiction can be raised at any point of time as per law, full stop. Also, the learned additional PP points out the earlier aspect of the earlier round of litigation and submits that perhaps this court would not be able to go into the aspect of quashing of the complaint case all over again. Full stop.
That I also agree.
That's okay.
That's I agree.
That's fine. But actually, if but one can always be aggrieved. It's a different stage, cognizance and then the charge. I may be aggrieved by the framing of the charge. It's a different matter that if the charge is interfered with, then the entire proceedings goes. You know, that's a different matter. But that will not prevent me from being aggrieved by the framing of charge or challenging it.
No,
That's okay.
we are not. That's why, Milord, we have
That's
put in challenge.
That's fine. But you can file a petition, with,
With for
revisional. Then
revisional. My lord can observe that. So, my lord kindly observe that.
Upon considering the matter, the aforesaid prayer of the learned senior counsel is allowed. The instant criminal petition is disposed of upon withdrawal, giving, however, liberty to the petitioners to file an appropriate petition challenging the order dated 19/2/2020, framing charge against them under 166A. That will suffice.
I agree.
That will suffice.
Great.
That will suffice. Sometimes the finer points of law can be quite challenging. So only one matter is there for it. Should we finish it?
And one review petition of Ajal Bank.
Huh?
One review petition.
Review petitions at 2 o'clock.
Yeah.
Item 6, who is there for item 6? This is for, should we take it up now or at 2 o'clock?
What's it?
That charge sheet has been submitted.
Yes, yesterday, Lordship.
Or yesterday only, no?
Yes, but by that time, Lordship, 90 days expired on Lordship, 27, Lordship.
Oh, so that matter.
And by the time charge sheet was submitted, it has already been 92 days, Lordship.
Okay,
So,
no, now, even now, if we grant bail, it can be, we do not say default bail, we just say bail, What are the allegations? Very serious or something?
Lordship, basic allegation is that the online job fraud and financial scam through Telegram. Lordship,
Yeah, let me check. He was arrested on, we made that calculation yesterday,
for
28/4,
28 April.
2026. Remanded on 29.
29.
And the charge sheet is filed on
29.
29/6,
Yes.
29/7.
29.
On the 90th day,
92nd.
29 will be 92nd day.
Yes.
Then he has become entitled to. Oh. Third, invoking 483 BNSS, the petitioner is seeking regular bail in connection with cyber crime PS case number, so and so. Please take it from there. Full stop. The gist of the allegations is stated to be committing alleged acts of online job fraud
Lordship.
using Telegram.
Yes, Lordship.
Full stop. The petitioner was arrested on 28/4/2026 and first remanded on 29/4/2026. The learned counsel had earlier contended that perhaps the applicable statutory period of 90 days is also over. Full stop. The Upon taking instructions, the learned PP submits the wireless communication received from the IO, stating that the case has in the meantime been charge sheeted upon completion of investigation by its CS number 8 of 26, dated 29/7/2026. Full stop. Next paragraph. The learned PP, in his usual fairness, submits that even going by the date of the charge sheet, vis-a-vis the date of first remand of the petitioner, comma, the charge sheet came to be filed on the 92nd day, right? Made your calculations. Full stop. Next paragraph. In any case, the investigation is also over. And in the entire facts and circumstances, and considering the completion of investigation and the length of detention, the petitioner is allowed to go on bail of 50,000 with one security.
Lordship, can it be
30,000 with one security of the like amount, the satisfaction of the concerned learned court, which is CJM.
Lordship, it's session trial. Cyber, yes, cyber,
UPI.
cyber.
It's Sessions Court
Yes, sir.
because why special judge?
It's
Special.
cyber crime PS.
Right. A concerned learned court, you write special concerned learned court only, you write will be flexible. And subject to the following conditions, he shall be available for trial if one commences. Number 2, he shall not hamper or temporary residence and shall not commit any illegal activities or offenses. Violation will entail cancellation of the bail. Bail petition stands allowed in this post.
Deeply obliged.
My lord, kindly a minute, my lord. My lord, I'd beg to mention 94 listing tomorrow, my lord.
Tomorrow,
But it's a civil petition, my lord. If tomorrow it can be taken.
Monday,
Okay, Monday, my lord.
Monday.
Monday, much obliged.
Okay, we have that ISOL matter, no? That's why I made you free.